arbitrationagreements.org. If you're here, it probably means you've got some interest in the legal sphere, particularly in the intriguing process that unfolds once a summary judgment is granted. You are in the right place. So, let's dive right into it, shall we? Before we get started, please give this video a thumbs up, press the subscribe button, and hit the notification bell so you can stay up to date about important dispute resolution topics, which can help you keep costs low when problems occur. You know, it's not an everyday event where a judge comes to a decision before a case even goes to trial. It's a bit like skipping the queue, isn't it? But when it happens, it happens. And here we are talking about the now what of it all. First things first, let's just grasp what summary judgment really means. Essentially, it's when a judge decides that there are no genuine issues of material fact that need to be decided at a trial. It's a bit like saying the facts are clear and undisputed, so let's not waste everyone's time with a trial. But now the judgment has been granted, and what happens next could be a variety of things. The losing party can, of course, accept the judgment, but where's the zest in that, right? Most often they decide to appeal the decision, kind of like asking for a second opinion. I should tell you though, the statistics around this aren't too promising for the appealing party. According to a study conducted over a few years, only about 23% of appeals resulted in a reversal of the summary judgment. It might not be a high percentage, but it's not zero, right? So there is a glimmer of hope. Now, if the appealing party decides not to walk down that road, what we see happening is the case wrapping up rather quickly. It ends then and there, and both parties go their separate ways, hopefully with some lessons learned and maybe, just maybe, a bit of closure. But let's not stray away from the appeal path just yet. If you choose to tread that path, know that it comes with its own set of challenges. The appellate court takes a close look, scrutinizing the summary judgment in detail. It's a process that demands time, patience, and yes, some more of those green bills. Now, I won't leave you hanging there. Let's talk about the timeline a bit, shall we? On average, from the filing of a notice of appeal to a final decision, it might take anywhere between 12 and 24 months. It seems like a long time, but justice, as they say, takes its own sweet time. Remember, a summary judgment might seem like a quick resolution, but it opens the door to a series of steps that could potentially lead to a resolution that's satisfactory to both parties. Or it might just be the final say, bringing an end to a dispute that probably has taken up too much energy already. For more information, please visit arbitrationagreements.org. Also, what do you think about the steps that can take place after a summary judgment? Do they seem simple or complicated? Drop a comment below and let us know your opinion. Please do not forget to give this video a thumbs up, subscribe to our channel, and hit the notification bell so you can receive the latest updates about dispute resolution that can help you succeed.